All right, for this screencast, we're going to be getting into the Supreme Court. This is a nice little picture I took while I was in D.C. Building there built in the 30s. So not one of the original buildings. The original Supreme Court, in case you're wondering, was actually housed in what is now the nation's capital. If you go on a Capitol tour, you can see it. Very dark, dreary type of building. The new one is much nicer. Anyway, the justices themselves, they're actually sitting in order. They go from right to left, back and forth in terms of seniority. So front and center is John Roberts, appointed by Bush, moderate conservative. And then to his right, the longest serving member on the court currently, Justice Thomas, appointed by George H.W. Bush, 1991. Ginsburg, a Clinton appointee. And then you have Breyer, another Clinton appointee. Then Alito, another George W. Bush appointee. Roberts, also a W. Bush appointee. He was appointed as Chief Justice. And then we have the Obama judges. We have Sotomayor and Kagan. And then the Trump justices, Gorsuch and Kavanaugh. And if you're keeping track, conservative, super conservative, very liberal, pretty liberal, staunch conservative, liberal, staunch conservative. Probably too early to say with Kavanaugh, but he's billed as a conservative. So that's a 5-4 conservative majority currently on the court. And of course, the big question is what happens when Ginsburg retires and when that takes place, because that could have a tremendous impact on a lot of things depending on who wins the presidential election in November. So anyway, let's go to the outline and take a look at some of this stuff. And by the way, I don't know that we need to go through this from the original outline. Let's go over the review packet. And as always, look at the enduring understanding. This is the one thing you're supposed to always remember with this stuff. So the design of the judicial branch protects the Supreme Court's independence as a branch of government, and the emergence and use of judicial review remains a powerful judicial practice. Now, don't forget, Federalist 78 is where the judiciary is really spelled out in terms of the provisions that it should have. And some of the most important: serving during good behavior, appointing judges, not electing judges, and the provisions regarding their salary. So we don't need to really go through this at this time, but that's where it mostly is. And don't forget that it was Marbury versus Madison was the court case, the midnight judges case, where all of this judicial review stuff came out in the open for the first time, where the court basically argued that this was a power that they should have, and basically just parroting what the arguments were in Federalist 78. All right, so the first objective is to explain the principle of judicial review and how it checks the powers of other institutions and state governments. That's one thing you should remember. Checks and balances does not just apply among the three branches and the bureaucracy. It also involves the state governments and what they're doing. Let's go ahead and look at our second subset here, the foundation for power of the judicial branch and how its independence checks the power of other institutions and state governments are set forth in Article 3 of the Constitution, Federalist 78, and Marbury versus Madison. Now, the Constitution is extremely abbreviated with regard to Article 3, and the reason for that is we essentially took the system of English common law, which was a body of law that had been developed for hundreds and hundreds of years, and made it our own. There was nothing novel or unique about the way we set up our judiciary. And Article 3 basically puts into actuality the arguments set forth in Federalist 78. And notice Article 3 begins the exact same way as Article 1 and 2, setting forth, in this case, the judicial power. And notice it shall be vested in one Supreme Court and such inferior courts as the Congress may from time to time ordain and establish. Now, here's a very important observation that in the past has been the subject of numerous questions on the AP exam. And this year's format probably won't be as likely in the sense that you're going to be, only answering these FRQs. But still, an important thing to remember is that the entire federal judiciary, except for the Supreme Court, is created by Congress. In fact, it's kind of one of the historical little tidbits that's good to know is that the first law that did this was the Judiciary Act, the same law that was the subject of Marbury versus Madison. And if you don't remember what that was about, Marbury was a judge who was appointed by outgoing President Adams, and he was an 11th hour judge, and the incoming Jefferson administration refused to accept his commission. So he went to the Supreme Court because the Judiciary Act said he could. Now, the Judiciary Act, it's a pretty ambitious thing to try to create the entire federal judiciary from scratch, which, except for the Supreme Court, which is what Congress had to do. So if you actually bother to read through it every now and then, you can see that it literally is establishing all these different federal courts. Here's specific courts in talking about the circuits, judicial circuits, and on and on and on. But what we are interested in is how this document and the court's interpretation of it dramatically increased the power of the Supreme Court in basically setting the stage for arguing that the courts have the power to declare laws unconstitutional. So let's review real quickly a couple of things about this. This is a law passed by Congress that is setting up the judiciary. The Constitution expressly gives Congress the power to establish the federal judiciary with the exception of the Supreme Court. So when they did it, I don't know that a lot of thought necessarily was, they were doing all kinds of things. And anyway, lo and behold, this one section is called into question in the case of Marbury versus Madison. And we don't need to belabor it here, but be it further enacted, the court shall have exclusive jurisdiction on blah, 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 blah. And it starts to get into all this stuff with jurisdiction. Well, there's one problem with that. The jurisdiction of the Supreme Court has already been set by the Constitution. If you go to the Constitution, it's right there in Article 3, Section 2, the judicial power shall extend to all cases. And it talks about the jurisdiction of the court in all cases affecting ambassadors, other public ministers, and consuls, and those of which a state shall be a party. The Supreme Court shall have original jurisdiction. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction. Appellate jurisdiction is the authority to review. Original jurisdiction is the authority to hear a case for the first time. So in our federal judicial system, we have a three-tiered setup, and once again set up by Congress in the Judiciary Act, and we have what are called district courts. These are the courts of original jurisdiction. If a case is appealed from the district courts, it can go to one of the circuit courts. The circuit courts of appeal is usually the next step in a case, and if that outcome is not satisfactory, there's a possibility of appealing to the Supreme Court. And of course, the Supreme Court has total discretion over which cases it hears, but the vast majority of cases heard by the Supreme Court are using the court's appellate jurisdiction. So, not to get into a whole thing on Marbury versus Madison here, but it is pretty important to understand. So in Marbury versus Madison, William Marbury looks at this document, the Judiciary Act, and looks at this section on jurisdiction, section 13 here, and it says, Supreme Court shall have the power to issue writs of prohibition when proceeding blah, 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 and writs of mandamus in cases warranted by the principles and usages of law. So for Marbury to walk into the Supreme Court and say, hey, you got to hear my case, he would be laughed out of the building today because everybody knows that you file a case like this starting at the district court level or perhaps in the court there in D.C., but not directly to the Supreme Court. So why did Marbury think he could? Because the law said he could. And all the Supreme Court did is they looked at this and they looked at this stuff about jurisdiction, and then they looked at the Constitution, and the Constitution has already established the jurisdiction of the court. So a law passed by Congress does not supersede the Constitution. If you want to change the jurisdiction of the Supreme Court, you have to do it through the amendment process, which is a much more arduous type of procedure. And you may remember a 2/3 vote in both the House and Senate. It's the most common way to do that, with 3/4 of the states that have to agree to it. So that is a really, really tough thing. And that's so anyway, this is the whole situation with Marbury versus Madison. And the result was the court essentially gave itself, or officially recognized, I guess we should say, this power of judicial review, which has enabled all of the other decisions that they have made since then. All right, so as you can see, it wasn't just one thing that led to this judicial review. It took the Constitution, the arguments set forth in Federalist 78 in the case, which kind of ferreted it out officially. And what's amazing about that is no one has since made the argument that the court should not have this power. It's widely recognized, and at least for the foreseeable future, it's probably not going to ever be challenged. All right, a couple things about the court. Let's go through the rest of the outline here. Explain how the exercise of judicial review in conjunction with the Supreme Court's life tenure can lead to a debate about the legitimacy of the Supreme Court. Now, this is a very important theme, and it is one that some of you may have a little bit of difficulty understanding, but it boils down to this. The Supreme Court can issue whatever rulings they see fit. They're the highest court in the land, but if they start ruling in a way that contradicts the way people in society feel about something, and they do it frequently, people are going to question whether the court is doing the right thing. And so when the court, considers cases, it has to really, really evaluate whether the timing of the case is appropriate, and whether, for example, ruling on same-sex marriage, or if you had that case in the 80s, I don't know that the court would really have taken a marriage equality case with regard to same-sex marriage, because it wasn't really in the public eye. And of course, that started to change in the 90s. And by 2015, when that decision actually was handed down, the court's ruling was largely in alignment with, I would say, the majority of people. Not everyone is going to agree with it, obviously, but enough people did that the court felt comfortable making that decision at that time. So let's talk about some other things regarding the court. Precedent is a very important concept, and stare decisis. The court is largely, as I said, a product of English common law, which basically means that once they figure something out in terms of a judicial principle, it tends to stay for a while. So stare decisis is a Latin term. It means let the decision stand. And basically, it's a policy of the courts. It's a principle of the courts to rely on past precedent. That doesn't mean that precedent cannot change. But it does mean that once a decision is handed down, it tends to have some staying power. So what would cause the court to change its mind? Well, lots of things. Society could change. The makeup of the court could change. The overall ideology of the court could change. Now, this idea of legitimacy has actually gotten a lot of attention in this course rewrite. And I think it's important to really understand what it is. And I think this item in the outline really kind of sums it up. Controversial or unpopular court decisions can lead to challenges of the court's legitimacy and power, which Congress and the president can address only through future appointments, legislation changing the court's jurisdiction, or refusing to implement decisions. And it's really the last one that is about all you can do, because these other ones, you have to wait for a vacancy, and you just can't change. Now, theoretically, the Congress could enlarge the size of the Supreme Court. But if you start doing that, then it's kind of a dangerous path, because you're setting a precedent that's going to further dilute the court's power, perhaps, if you start playing politics with these court appointments. And you may wonder, well, how can you just refuse to implement a decision? Well, if it's out of alignment with public thinking, it happens quite frequently. Now, one case I like to use as an example of this is Gonzalez versus Reich. Now, this was a 2005 2005 case where state of California had passed a medical marijuana law, and the question was, does this contradict the Controlled Substances Act? Because under federalism and the Supremacy Clause, there's no question that a federal law supersedes any state laws. And in this case, the law in question is the Controlled Substances Act, which lists marijuana as a Schedule I narcotic with no accepted medical use. And this case has not been overturned. It is still on the books. It was a 6-3 ruling, so it's not the strongest ruling, but not a 5-4. And nobody is paying attention to it. And if you don't believe me, you can look up this stuff on your own. And it's really quite remarkable that in now 1, 2, 3, 4, 5, 6, 7, 8, it's like 11 or so states and the District of Columbia, our nation's capital, recreational marijuana is fully legal. And even in states like Texas, we have just recently allowed things like CBD oil, which is a hemp-derived product, and some of the most conservative states are decriminalizing, which is not the same as legalization, but it effectively tells the police, don't bother with this stuff. We got better things to do and stuff like that. So once again, the reason for bringing this up is to really understand this idea of legitimacy. And should the court have ruled the way they did? I don't think the ruling was wrong, but I don't think they would hear a similar case today, because it would contradict public opinion. So anyway, that's really the biggest thing to understand about this idea of legitimacy. The court really has to be careful which cases it chooses, because if people routinely get in the habit of ignoring court cases, then the power of the court has been completely undermined, and that is not a good situation in a system of checks and balances where the court is the only safeguard. They're the guardians at the gate regarding what is and what is not constitutional. And if people just say, yeah, whatever, and they don't really care about the court, the Supreme, why do we have the Supreme Court? And then we just defer everything, I suppose, to Congress or the president or the states or whatever. And that's not what we want as a society. We have to have some sort of safeguards to protect the sanctity of the Constitution, and that's the role that the Supreme Court plays. Let's look at some sample questions. During his confirmation hearing, Chief Justice John Roberts said that in Roe v. Wade, it's settled law of the land. The statement suggests that in a case that challenges the constitutionality of legislation restricting privacy and reproductive rights, which of the following should be a key factor in the court's rulings. And our choices are briefs submitted by interested parties, contemporary societal norms, the consensus of the other judges, reliance on legal precedent. And this is, without question, the correct answer. Anytime you see settled land, he's basically saying we believe in stare decisis, and that's what D is all about. So another one, the Supreme Court issued a ruling that was unpopular with the majority of Americans. The president and Congress might be able to lessen the impact of the decision by A, reducing pay of justices, B, overruling the Supreme Court's decision by a 2/3 vote in Congress. Now, if you've been paying attention at all, you know that both of these are ridiculous choices. I guess we didn't look at the pay provisions quickly. Go ahead and take a look at that. This is, again, Article 3, judicial power. Judges both of the Supreme Court and inferior court shall hold their offices during good behavior. That means a life term. And shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. You cannot punish them using the power of the purse. Unlike when we get into the bureaucracy and we talk about congressional oversight, where they can use the power of the purse to go after agencies they don't like. They cannot do that with the courts. Okay, back to the question. Impeaching the justices in the majority. Letter C, impeaching the justices in the majority. Letter D, refusing to actively enforce the decision. Well, it is possible to impeach judges. It's very, very rare, very difficult to do. So D is the correct answer, refusing to actively enforce the decision. That is exactly what has happened with our drug policy, and which is why it's such a good example to bring up, because it's just so flagrantly ignoring the court. I wonder sometimes if the court regrets that ruling. Now, probably the second on the list in terms of your understanding of the court's role in our society is this debate between judicial activism versus judicial restraint. And this is something that people are just always going to disagree about. But here's the basic thing, okay? So should the court be actively deciding cases, choosing cases with the specific goal in mind of creating policy? And if they do so, they are said to be an activist court. And the problem with that, and we're going to go back and review some of these founding documents as we look through this. And, going back to Federalist 51, if I can find it. This is what Madison said about that. In Republican government, the legislative authority necessarily predominates. The remedy for this is to divide the House into two parts. And so Madison here is really expressing the idea that most policy naturally emanates from the legislature. And when you have the courts starting to wade into policy areas, it really calls into question whether that's a good thing, because there is no check on the court in the sense of interpreting the Constitution other than to amend the Constitution itself. And that is a really tough thing to do. So some activist decisions are really good ones. We have Brown versus Board of Education. Nobody would disagree with that today, but at the time it was controversial. So again, using the court's power to make policy is the biggest criticism. And judicial restraint is simply avoiding ruling on areas where the states have refused to act. So a classic example in this, and this is controversial, but it illustrates it so well. Now, again, this is a controversial area, but if you look at this map, this is from a Wikipedia article, and I suppose it's fairly reliable, but I guess we can just use this one. Immediately prior to Roe versus Wade, abortion was illegal in 30 states, legal in the case of rape in 1 state, legal if there was a danger to a woman's health in 2 states, only fully legal in 4 states. So when the court ruled in Roe versus Wade that a woman had a right to an abortion, it was really a right to an abortion predicated on a theory that recognized an implied right to privacy as a fundamental right. And Griswold versus Connecticut was the case that established that idea of privacy as a fundamental right. And they did so based on this penumbra theory. And if you don't know what that is, basically, they didn't just look to one constitutional provision. They looked at several of them. So the First Amendment, the Fourth Amendment, the Ninth Amendment, which says you have unstated rights. Fourth Amendment's about search and seizure. Even the Third Amendment, which is the amendment regarding quartering of soldiers. You put them all together and you can deduce that our founding fathers would have probably agreed that there should be a right to privacy. And by characterizing it as a fundamental right, now don't forget, the 14th Amendment kicks in, and the 14th Amendment says, nor shall any state, you can pull it up here on the Constitution, deprive any person life, liberty, or property without due process of law. And of course, the operative language is liberty. So all of that to say that the court dramatically reversed 46 states' policies regarding abortion. And, if you want to get into an argument with somebody, start talking about abortion, because everybody disagrees. A lot about the country's roughly evenly split on this issue. And so it's why it typically doesn't make for a good debate topic, because passions run high and on and on. So anyway, but critics are going to say this is judicial activism and the state should decide. And if those who believe in judicial restraint, and the late Chief Justice Scalia was widely known to be an advocate for the states making policies like this. In other words, you want abortion to be legal, well, let the legislature say so, or let the states say so. The problem is that no politician wants to put their name on legislation like that because it's just simply too controversial. And this is where the courts come in. Now, once again, is this okay? And it totally depends on your point of view. So it's just kind of an ongoing debate. And that's why they characterize it as an ongoing debate. Just saw that. Okay. All right, so look at another practice question. The majority party in the Senate is concerned that the Supreme Court has made a number of ideologically dangerous and controversial rulings. Which of the following actions would the Senate take in their attempt to limit the court's power? A, replace Chief Justice with the Supreme Court. No, they can't do that. Pass legislation that would limit the impact of the court's recent rulings. Something they could do. Ratify a constitutional amendment limiting the court's power. The Senate does not do that. The states are the ones that ratify, so that's a distractor. Got to recognize stuff like that when they're playing tricks on you. Enforce term limits for the justices on the Supreme Court. Again, ridiculous if you understand checks and balances and the life tenure of the court. So B is our correct answer. So what can Congress do? They can pass legislation. All right, explain how other branches in the government can limit the Supreme Court's power. Restrictions on the court are represented by congressional legislation to modify the impact of prior court decisions. Constitutional amendments, judicial appointments, and confirmations. That's a very slow process. Both of these are really, really tough to do. But it's happening. And particularly with the appointment power, President Trump, as we said, is breaking records with regard to the speed of replacing judges at the lower courts. And of course, depending on what happens with Justice Ginsburg or possibly Justice Breyer or some of the other ones that are getting up there in age, could have a very strong impact on that. But again, this is something that takes time. You have to wait for those openings to come up. The president states evading or ignoring Supreme Court decisions. Now, I think a lot of people would be like, you can do that? You can just ignore them? Of course you can. And again, going back to legitimacy, why does the court think very carefully about which cases they hear? Because they don't want to be ignored. And if they're making rulings that are out of alignment with public thinking, that's exactly what would happen. And then, of course, legislation impacting the court's jurisdiction. This is one thing that Congress can do, as long as they don't contradict the language in the actual Constitution. So last thing I want to get into is the general order of how a court case transpired, in case you get a question on that. Hint, hint. So here it is. The Supreme Court has total discretion as to which cases it hears. It takes 4 out of 9 justices to agree to hear a case. And once they have agreed to hear a case, they accept it. It's called a writ of certiorari. And a writ of certiorari means that they're going to make the matter certain. So certiorari is a Latin term. Once they agree to hear the case, they immediately summon the briefs that have already been circulating in the lower courts, and this time usually attracts third-party briefs. Those are called amicus briefs, friend of the court briefs. So if there's a big case involving gun ownership or a big gun manufacturer is getting sued, I think that's an actual case right now, guarantee the NRA, National Rifle Association, is going to be filing briefs arguing their side to the case. And once the case has been accepted, once the briefs have been submitted, the judges have to have time to read them, of course. They schedule what are called oral arguments. The oral argument typically happens from late December. Well, oral argument typically happens in January, February, March. Then the case goes to what's called a conference. They vote on it. They write the opinions, they assign the opinions, and then usually around June or July, early July, they announce the decisions. And this is all done in total secrecy. One of the few institutions of government that actually keeps a secret. Pretty remarkable. And that's the process. And this process, again, is basically over the course of a year. Now, the last thing I want to get into here is the issue of decorum. And I put this in your Unit 2 packet, Unit 1 and 2 packet, and it's there in the back with the review topics if you want to see it for yourself. Or you can just go to the review. I think it's in there too. But anyway, this is a list of justices and the presidents that were there, and if you see opposite colors, that indicates divided government. Now, what's really remarkable is if we go back in history, all the way up until we started seeing diversified news, cable news, the internet and stuff like that, this was a pretty mundane process, and there was a great deal of deference on the part of the Senate to the president. And as you can see, these are unanimous votes in favor of the justices. So here you have Ford, who appointed John Paul Stevens during a period of divided government. His appointment was confirmed unanimously. Reagan, 99-0, 98-0 for Scalia. Not a single person on the Democratic side objected to Scalia during the actual confirmation vote. Absolutely remarkable. And then we get into some really interesting ones with Clarence Thomas, who was the second African-American to serve on the court. He replaced Thurgood Marshall, but was an absolute champion of the civil rights movement. And a lot of people on the left just absolutely went apoplectic when Clarence Thomas, who was a very, very staunch conservative, probably the most conservative member of the court, was named as a replacement. And so you can see that indicated in the vote here. Very contentious. And then as we get into the more recent era, we start to see a deviance from this deference to the court the deference to the president's choice, and all of these contentious votes. And I don't have Kavanaugh on here, but Kavanaugh was also a very split along party lines confirmation. And this is related to another topic, which is the decorum of the Senate, which is beyond what we need to get into here. But people just are a lot meaner now with politics than they used to be. And you can see that in these court appointees.